Yes, in fact, we are. It's just easier because there's several cases. In the case of Christian Taylor, where it was ruled that an iPhone can be warrantlessly searched and seized. But there's cases in Ohio where the exact opposite has been ruled, and it's really hard for the states that haven't decided what to do with that.
Well, it may be easier, but is it constitutional? We know that the United States Constitution, including the Bill of Rights, sets the floor with respect to liberties to which citizens are entitled. But as a matter of federal constitutional law, the states are free to extend greater freedoms to their citizens, including through their civil rights, including search and seizure law.
Yes, oh, sorry.
In light of that, is federalizing the law of search and seizure such a good idea?
We're not suggesting necessarily federalization, more of a coming together of states to discuss these issues. These are such new issues of search and seizure. What is the scope of search and seizure without a warrant incident to a lawful arrest? Can you search the whole iPhone? How far can you go?
Well, what do you suggest?
I would agree with the case in state of Ohio v. Smith, where it was ruled that even if you've been arrested lawfully, your iPhone, if it's going to be thoroughly searced, your cell phone is going to be thoroughly
Arrested
searched.
for what, though?
Any sort of criminal charges.
Okay, and then what about the iPhone?
That you need a search warrant to search an iPhone because it's like a computer. There's so much information that can be found on it, unless, of course, there's exigent circumstances.
I would disagree with my colleague.
What kind of exigent circumstances would exist for an iPhone?
For instance, if there's some sort of information needed to be known, say someone kidnapped someone and hid them somewhere, if you need to figure out where they were, you're trying to find the victim, of course you're going to go through the person's iPhone and figure out who was the last person they talked to and thoroughly search that for any sort of evidence when there's danger in life.
Well, I disagree in that we need to apply old case law to today's technology. We need to be able to take, such as if you were to compare an iPhone to like a backpack or a purse, there's different types of things that you carry with you at all times, such as you can have in a backpack letters, which can be comparable to like an email. So we need to, again, apply old case law to today's technology.
Well, what's wrong with what Ms. Atkinson is suggesting as far as an exigent circumstance?
There's nothing wrong with the exigent circumstances. I was disagreeing with her in that we need to make it easier for the law enforcement to obtain that evidence.
As long as government doesn't seek content of email messages, text messages, or anything else that might be sent over the air, what's wrong with the government getting at least the registration of those devices?
I would say that there is nothing wrong with that. Just as the government can have phone records with showing the number, but not the content of the call. But it's easier to distinguish between the phone number and the content of the call than it is to distinguish between the address of the email and the content of the email because of the way the internet works.
In the context of computers and emails, what issues of the Fourth Amendment are called into question?
For instance, when we quoted Ziegler, the case, his employer came up to his work computer, looked on his email and saw child pornography. The court ruled that Ziegler did have a reasonable expectation of privacy, even though it was the work's computer. I would disagree with the case. I would say because the computer was issued from his employer, that the employer had every right to go onto that computer.
Are you suggesting that under those circumstances, the employer was not engaging in a search in the constitutional sense?
Yes, I would agree with that statement because he's searching his own property.
And was the employer acting as a governmental entity?
Excuse me?
As an agent of the government?
I think he was just acting as a citizen looking at his own property.
There are even more recent.
So then is the Fourth Amendment even called into question in that?
Ziegler called it into question, and the court did rule that he did have reasonable expectation of privacy.
Okay, why? I mean, if the employer wasn't acting as a governmental agent, then why did they have a reasonable expectation of privacy from work?
Excuse me?
Probably not a very good question. Why, if it's not the government that's looking, okay, at you, how does it call in and I'm not spitting this out, help me spit this out. If it's not the government, then the Fourth Amendment's not even at question, is it?
Well, I believe there was a contract that the employers would be, the employees would be acknowledged, they would be known, they would know when the search was going to happen, and this was a warrantless search. I mean, he had no knowledge of the search going to take place. So there was a contract that was violated.
Well, right, but why does the Fourth Amendment and its responsibilities or its separation of rights and responsibilities with respect to government, why does that apply at all in the private context?
Because he turned over the information to the government, and it was a warrantless search. He didn't consent to give that information to
But
the
at
government.
the time that he got the information, was he working for the government? As an agent for the government?
No, he was not.
He was working as an agent for the private company?
Yes,
Okay. Then why the expectation of privacy?
because the employer had sent the records to he had the FBI come in and search the man's computer after he had knowledge of this, and that was a warrantless search of his computer.
Okay, so the original search wasn't a problem, but calling the FBI in was the problem?
Yes,
Yeah.
yes,
Okay.
calling the federal.
Okay. How would that work if we were talking about, say, a university searching the email account that it has given its students? Would that also qualify for Fourth Amendment treatment?
It depends on if it's a public or private university, I would say. If it was a public university, I would say the students is allowed more privacy because it is a government funded. You're paying for the college, some of it through your taxes. And if it was a privately funded, there's a lot less privacy and freedoms that you're allowed there.